Hello and welcome to Verdictum. I am Ananya Singh and today we have with us Senior Advocate Mohan Katarki. Sir is a counsel at the Supreme Court of India and a well-known expert in transboundary water law. He has played an instrumental role in cases relating to transboundary water disputes of national as well as international borders and has represented in water disputes like Kaveri, Krishna, Ravi and Vyas. Sir has also published several papers on the subject and has enlightened people at national and international conferences about water laws. And today, that's what he will be highlighting on for our viewers. A very warm welcome to Verdictum, sir. Pleasure to have you with us today.
Thank you, Ananya. It's my pleasure to be on the Verdictum.
Before we begin, I would like to let our audiences know that we have bifurcated this interview into three broad sections, dealing separately with international water laws, Indus water dispute, and Ganga Brahmaputra river dispute, respectively. So we will begin first with the international water dispute, sir.
Sure.
Sir, India is home to international rivers. Would you please elaborate that geographically where India stands in Indus, Ganges, and Brahmaputra international water?
Yeah. We all know that on the northern side of India, there is a Himalayan plateau, also known as Tibetan Plateau. It is known these days in international parlance as a third pole because it's really a tower of water. Hundreds and thousands of glaciers are there in Himalayan plateau. As a result, it holds enormous quantity of water, and rightly, it is being described as third pole in the world. Now, what does it mean? It means that 4 international rivers take birth in the Himalayas. These are Mekong, which are not concerned, but it takes birth in the other side of the China and flows down to the South Asian countries. But the 3 other rivers, Indus, which originates in Himalayan plateau in Tibet, then flows into India, then goes into Pakistan, and finally joins Arabian Sea. We have other 2 rivers, Ganges, that starts again in the Himalayan plateau, flows into India. Some of the tributaries originate in Nepal. Finally, they join the Ganges in India. Then it flows down to Bangladesh and to the Bay of Bengal. Then we have Brahmaputra, which is known as Erlong in China. It originates in the Tibetan part, then flows eastward, takes a U-turn, then flows westward and enters India, then finally enters Bangladesh and goes down to sea. Now, as a result of these 3 rivers, we are riparian, naturally, but what sort of riparian differs? With regard to the Indus, India is the upper riparian state. Its position is different. When it comes to the Ganges, some of the tributaries of the Ganges, as I told, originate in Nepal. As a result, the Nepal becomes headwater state or upper riparian, and India becomes a lower riparian. But as you go down, the river Ganges enters Bangladesh, then the Bangladesh becomes lower riparian, and India becomes an upper riparian. So the chemistry changes. Same thing with the Brahmaputra. It starts in China, flows down to India. India is a lower riparian. It has all the concerns of any lower riparian. But as the river flows down to Bangladesh, Bangladesh becomes a lower riparian and India becomes an upper riparian or a mid riparian. So India is really in a hot water with regard to the position to be taken in international law while asserting its rights qua the co-riparian states. And therefore, every time when India works out its position, its case, it has to take a nuanced stand which is not an absolute stand, but a stand which is adjustable, which can be properly be described as an equitable stand.
Sir, but why do conflicts or disputes between riparian states arise in international water disputes? And what is the remedy to resolve these disputes involving scarce resources?
See, the riparian disputes have started coming to the fore in the middle of the 19th century. Before that, there used to be disputes. Some small disputes used to be there with regard to the diversion of water. There were navigation disputes. But when the high dam technology was invented by civil engineering in the middle of the 19th century, around 1850, the upper riparian states started constructing dams. It became possible for them to construct dams. As a result of the holding of the water, the downstream states, where usually the delta occurs, which is a natural gift of the nature, where the water was naturally used without any construction of dam or even the canals, because delta is a flat land where the river, as soon as it enters the head of the delta, it breaks due to the lack of gravity. That's why you have the famous deltas of Nile, Mekong, Indus, Kaveri, Krishna. They are the places where the civilization grew up because of the abundant water and as a result of the security of the food, life, etc. So when the dam technology came up, the lower riparian, the delta, felt threatened that if this is the technology that man has invented to dam any river to any extent, what's our future? Will our delta go dry? So all kind of fears started coming up, and they were the natural fears. Nothing wrong in that. Should be there. Should have been correctly entertained. The question started: what are the rights of the old users versus the new users? And water disputes began to emerge when the downstream state took up the objection against the construction of high dams by the upstream state. That's the beginning of the water dispute, whether you look at the Indus dispute, whether you look at the Nile dispute, one of the most famous dispute, or the Mekong disputes now coming up, or a couple of the disputes in America also, particularly River Rio Grande or Colorado. So all it starts with a dispute between the old ancient users versus the new users who were deprived of water earlier, but with the advent of technology, they have become they are able to use the water, you can say.
Sir, in a conflict between upper riparian and lower riparian states over the sharing of international water, what are the different juridical theories which dictate the determination of water rights of riparian states? And which of them should be acceptable?
Yeah, there are broadly three doctrines which have been debated. The first doctrine was Harmon doctrine, that is, the absolute right of the upper riparian to hold the water within its territory, because it was understood in international law by Harmon, the Attorney General of US, who advocated this theory that a state is sovereign, and if it is sovereign, it has entire control over all the resources that lie within its territory, regardless of what happens to the downstream state or anyone. As a result of this doctrine of Harmon, the upper riparian states became almost an absolute owner of the water, regardless of what happens to downstream. This was advocated by Harmon because the dispute arose with New Mexico with regard to the River Rio Grande. But the same Harmon couldn't maintain this later, that is, America could not, when some dispute arose between Canada and America, where America was a lower riparian state. As a counter to the Harmon doctrine, a natural flow theory emerged. That is also called as law of integrity, or the riparian theory. under which the lower riparian has a right to expect the flow of water in the state of nature, and upper riparian has a right to take water only to the extent of primary needs like drinking water and other things, which are primary considered to be needs for the saving the life. As a result of this natural flow theory, which was very aggressively promoted by the downstream state, particularly the delta states, it became almost impossible for the upper riparian to employ the new technology of dam construction to dam any river, because you have to let down the water, except water that is required for drinking water or any life-sustaining requirements. That's how these two theories, which helped one state, harmon upper riparian natural flow theory or riparian theory, the downstream state, became unpopular. A wire media had to emerge. Then the concept of equitable utilization and no injury theory appeared. Initially, it was employed in the federal disputes between the states in a federation in Germany, in Switzerland, then in America. Soon it caught up. International Court of Justice in order case said that the riparian states are like tenants in common. All of them own the water to the extent of their requirement and utilization. Therefore, no state can claim exclusive right to the waters of international river, whether it is a lower riparian by insisting on a natural flow theory or upper riparian by insisting upon a right to sovereignty. Therefore, everything has to be equitably used, shared, because water is a res communis, that is the heritage of mankind. It has to be equitably and equally used by all the states, all the riparian states. So these are the three doctrines which are governing the distribution of water. But having said this, it's not that easy, because still the doctrine of equitable apportionment, which has a component called no injury rule, requires the upper riparian state in any origin dispute to protect the historical rights, of course, historical uses which are not wasteful, historical uses which, according to the modern standards of utilizations, are acceptable. But these are the matters of debate in detail. That's how still the subject remains hotly debated as to what rule within the equitable apportionment prevails.
So you just spoke about the equitable use and no injury theory. So is there any special treatment for drought areas or environmental needs and, as you mentioned, historically committed uses?
Yeah, there is. In equitable apportionment, several factors are considered: the climatic factors, geographical factors, the contribution of the water, etc. But three factors which have become very popular these days are the drought areas. If a particular riparian state has a drought area, certainly that area requires to be compensated with better facility of water. You cannot allow people to live there without water, where they can't even grow a single crop, where they don't have water to drink, where you find women walking kilometers to fetch a bucket of water. So in those situations, the law says these considerations have to be given a special treatment. And as far as possible, we must try to supply water to them, even if it becomes at the cost of historical uses, because historical uses can be reduced by applying the modern technology. The intake of the water can be reduced. That's how it has been understood. Secondly, which has become very popular after 1971 Stockholm Conference, that is a duty to protect the environment, that each state has a duty to protect the environment, and water being a part of the environment, certainly we have a duty to protect. The problems arise in case of water, international water, is when states start constructing the dam, when they erect a dam, naturally they erect to hold all the water that is available up to that point. As a result, the downstream part of the river during the summer almost goes dry. It becomes a dry bed. That affects the flora, fauna, or some people, indigenous people, tribals, who depend upon the water for drinking water purpose and other things. So the concept of environmental flow has emerged, that you may take water, you may construct dam, but some minimum flows have to be maintained in the river to protect the flora and fauna. So this is called environmental flow. This is called ecological flow. Earlier it was called summer flows or minimum flow. So this has achieved its, has been recognized and achieved its importance. Apart from this, as I already said, historical uses require to be considered specially. As far as possible, the idea is to protect the existing economy. Nobody intends to destroy the existing economy and build a new economy. So there has to be balancing of the existing economy. There has to be balancing of the new economy that has to be built based upon the water, which otherwise goes to sea or wastefully used, and to supply water to the drought areas. Okay, these are the balancing factors, but certainly these three factors, drought areas, environmental needs in the form of ecological flows, and the protection of the historical uses, have received special importance in the equitable apportionment of the water of any international river.
So, talking about the treaties that have been formulated, can these treaties be abrogated? If yes, then how can these be abrogated? And can these be challenged in courts?
See, the treaties and international law are the product of duty to cooperate, right? Nobody can be compelled to have a treaty. Nobody can be compelled to have an agreement also, even in the private spheres. The states do enter into an agreement. But one problem when you compare to the private sphere, in case of the private sphere, or where the private law applies to individuals, if one is aggrieved by the continuation of the contract or an agreement, he can go to the court and ask for a declaration that this agreement has become unworkable due to the various circumstances, impossibility of performance, or doctrine of frustration he can apply. So many remedies are available, so many grounds he can raise. There is a remedy for him because the courts entertain a suit. There is a court called Court of Compulsory Jurisdiction. But in international law, there is nothing like a court of compulsory jurisdiction. There is no court at all. Even the International Court of Justice has a limited jurisdiction that it can entertain the complaints in a form of a joint submission by the states, or the matter is referred by the Security Council. Therefore, there is nothing like a compulsory jurisdiction. Some of the treaties have taken advance consent to the states to refer the dispute to the International Court of Justice. But at the heart of the whole thing is there is a consent. Since there is no way one can sue the other state if he is aggrieved by the onerous terms of the agreement, therefore the international law recognizes a party to terminate the agreement. But again, it is not an absolute right. You can terminate the agreement provided you are able to establish, if you are called upon to establish that change circumstances, fundamental change in the circumstances that were envisaged at the time of entering the treaty has changed. This is governed by Article 62 of the Vienna Convention on Treaties. So that rule can be applied. By applying that rule, one riparian state can say that the treaty which we had entered about 30 years back or 40 years back is no more relevant because the rainfall had changed, or the yield has changed, or my requirements have changed, or the requirement of other states have been reduced. So various factors they can plead, or climate has changed. Now, particularly the climate change, one of the big factor, which has become certainly a ground for seeking revision of the international treaties on water. But again, you don't have a court with compulsory jurisdiction. You decide for yourself, then matter gets resolved by diplomatic talks, by diplomacy. If not possible in international law, the last remedy is war. Hope that one doesn't go to that stage, except that once it had happened in 1967, when Syria did not listen to the woes of Israel, that the Israel launched airstrikes against the couple of the dams planned by Syria, which would have reduced the water to the lake Galilee, and that would have affected the famous Israeli project of water carrier project. This is how the law is.
And sir, are these water treaties approved by the parliament? And if not, why there is no say of the public in such an important decision making?
Yeah, it is unfortunate that matters of such big importance, which affect almost a section of the population in the country, any country, are being signed by the government without any involvement of the representatives of the people. But that's how the law is. Under Article 253 of the Constitution of India, the Parliament can make a law for the purpose of implementation of the international treaty, but it is may if they want. Otherwise, as far as the core riparian state is concerned, with whom the treaty is entered, they are not concerned whether you make a law or not. As soon as the signature is put by the head of the state, the treaty binds, so it becomes enforceable. But with regard to the people, if the treaty were to take away the rights of the people, were to operate against the rights of the people or against the federal states, sometimes law becomes necessary, and Parliament in that case may have to employ Article 253 and make a law to implement the treaty internally in a smooth manner. But so far, none of the treaty which India has entered, Indus Treaty or a couple of the treaties with Nepal or Farak Accord, no law is made, and no law perhaps was thought necessary to make to implement them internally.
Sir, one thing you mentioned that equitable utilization is the norm. But India and its neighbors like Pakistan, China, Nepal, and Bangladesh, they have not ratified the UN Convention on the Use of Non-Navigable Rivers. So, in the absence of understanding on equitable use doctrine, what are the principles that these states should rely on?
Yeah, neither India nor Pakistan nor China nor Bangladesh have ratified UN Convention on Non-Navigational Uses of Water. This convention is a codification of the international water law or the international law relating to the sharing of the water. And since none of them have ratified, at the moment, if a dispute arises, if the conflict arises, we cannot rely upon the convention as the source of law. We'll have to go back to the customary rules of international law to find out what is the legal position. But let me tell you, what is being codified by the UN Convention largely acts as a guide. It may not have been signed by any of the states, but since it is a codification of the pre-existing law with some progressive developments, it will be considered as a guide. Even if you do not consider, if you go back and look to the customary rules of international law, it's almost the same, with little variations could be. But broadly, the law is same, that is rule of equitable apportionment, where all the states stand on equal footing and their right is determined by the equitable factors depending upon the needs and the climatic and geographical constraints. And if there are any special needs like drought areas, environmental requirement, or the historical uses, they receive special attention. So after considering everything as a whole, a share of a state, what is the cake? Each should get what portion of the cake should be given to each of the state will be decided. So accordingly, the cake will be cut.
Sir, now moving on to the Indus water dispute. Can you briefly explain the terms of the Indus Water Treaty of 1960?
Well, Indus Water Treaty, you all know that in 1947, when British Parliament passed the law called Indian Independence Act and granted independence to India, by the same law, they divided the British India into Dominion of India and Dominion of Pakistan a day before, that is 14th of August. So what was earlier a national river became overnight an international river. The disputes arose. In fact, disputes had arisen before the independence itself between the province of Punjab and the province of Sindh on the utilization of the water. The matter was referred to the Indus Commission, headed by Sir Benegal Rao, who was the advisor to the Constitutional Assembly of India, well-known personality, later became a judge of the International Court of Justice. So he presided over the commission in 1942 and submitted a report on the adjustment of the interest of both the provinces based on the principle of equitable apportionment. So, but before that report could be implemented under the Government of India Act 1935, the partition occurred. So after the partition, the Indus became an international river. So once it became an international river, the scenario changed. Pakistan came back with the argument of natural flow theory. It had earlier also argued, Sindh had argued natural flow theory before the Indus Commission unsuccessfully. Now the Sindh case is taken more vigorously by the Pakistan and tried to argue that we are entitled to have a natural flow and India has only limited right. It cannot have cannot divert the water beyond what is required for primary purposes and what it has already used. That is how the Pakistan put up, and India also put up the opposite case that we do have a right, being a sovereign nation, to cut off all the water. That's how we looked at it. But the ground reality is that upper riparians can always argue and do argue that we are the owners of all the waters that fall in our territory. We are the masters. But unfortunately, this can't be implemented because water flows by gravity. Until you construct a dam, erect a dam, the water keeps flowing down. So the status quo helped Pakistan because Pakistan kept on getting the water. It was not really keen for a treaty. All that Pakistan wanted to see was that India does not take up the construction of any dam, that is Bhakra Nangal. Okay, as long as this dam is not, which was taken up, but it doesn't progress, as long as that doesn't hold water, there was no threat to Pakistan. At the same time, India was very keen to complete the construction, and it needed a lot of money in those days, and it was depending upon the World Bank for the purpose of financing the project. So World Bank became a mediator, and the World Bank was able to play a role in having the treaty brought about between the two nations. And that's how the treaty came about. Now the treaty people are criticizing that, look here, what kind of treaty it is. I have to part to Pakistan 136 MA of water, and whereas India gets only 33 MA of water. That's true. Under the treaty, the water is shared in a very different manner, which are not done elsewhere. That India gets exclusive right to hold water with respect to the three tributaries, that is Ravi, Bas, and Satluj. Pakistan gets a right to hold, right to receive water with regard to Indus, main river, Jhelum, and Chenab. But India has been given some rights with regard to the utilization of water in Kashmir, which comes to about 3.6 MAF as of now. And India is also given a right to produce hydropower on a run-of-the-river technology without consumptive utilization. And the design of those hydropower projects is also being mentioned in the treaty. Right. So these are broadly the rights that Pakistan has exclusive right to the western rivers named in there, which are Indus, Jhelum, and Chenab, subject to certain utilizations permitted in India, including hydropower generation by non-consumptive. Whereas with respect to three rivers where only 33 MAF is produced, India has exclusive right to use all the water. It can just cut off the river at the border, but the river water is only 33 MAF. That is how the story goes.
So, as you mentioned that under the Indus Water Treaty, India is entitled to only a little share, that is about 20% share of the total water that is carried by the Indus system. Don't you think the treaty is unjust to India?
Well, the thing is, and again, we'll have to go back to the ground situation, whether India could have utilized the waters of Indus, Chenab, and Jhelum, because these rivers arise in Tibet, then flow down to Ladakh and Kashmir, part of it, yeah, the Jammu and Kashmir. And there was no way in those days, about 60 years back, to transfer the water from these three rivers to Ravi, Bass, and Sutlej, and so that India can use them. There is no technology that easily available, and it involved enormous cost also when there is a technology. So practically considered, these three rivers are of no use to India. And in any case, the water flows by gravity, it goes to Pakistan. So why not give them? All that India was concerned was three rivers, Ravi, Bass, Sutlej. In these three rivers, India was not willing to share any water. And it succeeded in its effort to hold the entire water in these three rivers. So if you look at it from this angle, what is practically possible, what is and what is not possible. What is not possible, we are not much concerned. That is the western rivers, Ravi, Bass, and Chenab, Jhelum, and Indus. Not possible. So we allowed them to go down. What was possible for India, that is Ravi, Bass, Sutlej, we succeeded in getting full rights over them. So if you look at from this point, it was a very fair treaty. But in the changed circumstances today, it's not so. Today the technology has changed, things have changed. You can transfer a quantity of water from the Chenab tributaries to the Ravi, Bass, Sutlej, at least to the extent of 3 to 4 MAF, which really helps for India in resolving the internal dispute between Punjab, Haryana, and Rajasthan. And I would strongly recommend, in fact, I written also on this, that we should renegotiate the treaty to this extent and see that whatever water that is possible, which can be transferred from western rivers to India, can be transferred. And let me tell you, even Pakistan doesn't need this water. I understand Pakistan needs this water. It doesn't. Out of 136 MAF of water which Pakistan has got in three western rivers, it has hardly able to utilize 102 MAF of water. And it has future plans for about another 10 MAF. About 21 MAF of water in any case will go down to sea. An enormous quantity of water. Why should it go down to sea? And no state has a right to water which it doesn't need. If Pakistan doesn't need that water, and it cannot say that I'll need it because I want to send it to sea. It cannot. Therefore, both the states should employ Article 7. That is where the article mandates for the party states to negotiate for the optimum utilization of the water. And this is a situation, according to me, to save the wastage, water being wasted to sea. Both India and Pakistan should sit together and renegotiate the terms of the treaty and allow India to transfer some water to its Ravi, Bass river. Maybe that out of the water transferred by India in Ravi, Bass river, it can give some water to Pakistan also. It's no problem. But this strict no transfer clause must go. We should be permitted to transfer some quantity of water which otherwise goes to sea, so that we benefit to an extent where Pakistan can also benefit. This is how optimum utilization can be achieved. This is one. There is another way of talk which the government of India has done on 27th of December. They issued a notice under clause 12.3 calling upon Pakistan to renegotiate the treaty, that there is a provision. Well, that's I fully support. It has started from a larger angle, and India should do that and should pursue this matter. It has already done. Should pursue it to the logical end.
Sir, if India and Pakistan were to renegotiate and modify the Indus Water Treaty, what should be India's main demands according to you?
Yeah, the first demand of India is that it will be permitted to transfer some water from the three western rivers, that is Indus, Jhelum, and Chenab, to the Ravi Vyas and Satluj to meet the shortages therein. First demand, we require about 3 to 4 MF of water minimum. If we can get more, it's great. Secondly, the hydropower generation, which the treaty already permits, has so many restrictions. These restrictions have to be removed because I'm unable to utilize my water for the hydropower generation. Two of the projects we planned, that is Kishan Ganga and the earlier Baglihar, Pakistan raised a dispute. Baglihar went to the neutral expert Lafayette, who held in our favor. The second dispute, Kishan Ganga, went to the arbitration headed by Schwebel, where India largely succeeded in getting the project cleared. So, but this is creating a lot of unnecessary bitterness between the two, India-Pakistan. So, if those terms are better defined in the sense having regard to the change circumstances, new technology available, that would help. The thirdly, waters are not to be viewed in an isolated manner. It has to be viewed in a larger geopolitical context. Today, people in India are very much concerned about Pakistan supporting the terrorism or promoting terrorism in India. So India should extract a firm commitment from Pakistan that under no circumstances they will promote or indirectly or directly support the terrorist activities. And if they do such thing, they will be held accountable before a joint committee or some joint court to be established under the treaty, so that that committee or that court can look into the allegations of any violation Pakistan commits that by promoting the terrorism. Such a thing can be added, but this is a political matter which depends upon various other geopolitical factors. I'm not an expert on international politics, but this is one thing India can insist, that is, at least can extract a commitment from Pakistan. Pakistan is no doubt under the international law, it is obliged not to support terrorism, but to extract a commitment has a different meaning, and that I think India should do.
Sir, can you also highlight that what is the dispute resolution mechanism that has been mentioned under the Indus Water Treaty?
The Indus Water Treaty has an inbuilt mechanism. There is a permanent commission where the commissioner appointed by both the states, India, Pakistan, regularly meet and sort out the differences, exchange the data and other things. That works. Then if the disputes arise, they are first debated before the joint commission. It doesn't work out, then they decide whether it should be referred to the neutral expert. There are a list of disputes which should go to neutral expert in annexure F. And there are some disputes which involve more than the technical matters, interpretation of the treaty with regard to the utilization needs and other things. If such questions arise, they will go to arbitration. Arbitration of 7 judges that is to be nominated by the World Bank, that has a different procedure. So this is how the dispute resolution mechanism is mentioned. And as I already mentioned, we have gone through 2 disputes, and again Pakistan has invoked the clause to refer one dispute to the neutral expert and one dispute to the arbitration with regard to the Rattle project. And India is opposed to that. And that's how the dispute is going now.
So now talking about the Ganges-Brahmaputra river dispute, what are the present and future plans of China on the Brahmaputra?
See, Brahmaputra river has, like Ganges, a lot of water. It is not a river with shortages like Indus. There's plenty of water, right? And at the moment, the catchment in China doesn't require this water for any purpose. So China has been cautiously taking up only hydropower projects where no consumptive utilization of water is involved, but only uh, power generation based upon non-consumptive utilization or run-of-the-river technology, it is called. So the present couple of projects they have taken up, there is no real threat to India as such. If these dams, which are meant for hydropower, are enlarged into big dam, holding more water, at the moment these are more of a diversion structures. But if the big reservoir is envisaged, it might create some problem during this summer. But that can be negotiated. I don't think there's any difficulty. But it is not that simple. China has a larger plan that northern China is, particularly the Gobi Desert, is in need of water, according to Chinese. And they have taken up ambitious project already to link a couple of the rivers from the southern China to the northern side, transfer the water, called South-North Diversion Project. Right. Now, only thing is, Brahmaputra, that's called along in China, is to be linked to this South-North project. If that is done, large water can be diverted to northern part of China, causing serious injury to the rights of India, particularly in the summer. The Assam and down Bangladesh, both will suffer, India and Bangladesh. So we are all concerned about it. Therefore, in order to avoid a dispute, today we are at a stage where we can avoid a dispute because there is still plenty of water is there, it can be managed and negotiated. Something like international commission to be constituted, like Brahmaputra International Commission, on the lines of Mekong International Commission constituted under the Mekong Treaty. Similar kind of a mechanism is constituted. The commission can go into the requirements of China, can go into the requirements of India or Bangladesh. And if the commission feels that there is enough water or the manner of utilization, pattern of utilization can be adjusted, they should decide. By this process, the water will be utilized without there being any dispute. So I'm sure the governments will take up the issue, but it is again a political matter, depends upon so many factors whether we should have or not. Purely speaking, from the point of water, it is necessary. But water, as I said, is not to be viewed in an isolated manner. It's a part of the international politics.
Sir, as you mentioned, the South-North Water Transfer Project. If China does decide to transfer the water of Brahmaputra to the northern side, what are the options that are available to India in international law to protect its interests?
Well, if China were to take up the project unilaterally without negotiating with India, or they may negotiate and give some data, but they can still go ahead because international law is clear that a state can unilaterally go ahead with the project. Right? It was so held in Lake Lanu case way back in 1940s, because one state cannot have veto power over the another state. India cannot say that China cannot take up without my consent. It cannot be said so. So similarly, it happens in other rivers also. The Bangladesh cannot tell India that you cannot take up any project on the Ganges without my consent. So that consent theory doesn't apply. So if the China were to take up this project linking the south-north to the Brahmaputra, the option for India is to go for diplomatic talks, to have it resolved diplomatically by constituting a technical committee, again like a Brahmaputra commission of the engineers of both the sides, engineers, economists, legal persons sit together and thrash out the issue. And if that is not possible, the issue can be raised before the Security Council in the United Nations. But the only problem is that in Security Council, China is the permanent member. Any solution against it, it will be vetoed. So Security Council is ineffective. And the third is both the states should agree. If China agrees, matter can be referred to an arbitration or to International Court of Justice for resolution of the disputes, which again is not that easy. The last one is very unfortunate, which nobody likes to do. That is airstrike, the war, as Israel did in case of dams in Syria. So that's the only remedy in the international law. Finally, what is right and what is wrong is determined by war. I hope that situation will never arise, but theoretically speaking, that is the remedy.
Sir, now talking about the issue between India and Bangladesh, there is the Farakka Agreement of 1996 in place. Has this agreement succeeded in mitigating the differences between the two nations, according to you?
Yeah, Farakka Agreement in 1996 was a masterstroke. Actually, many say such a complicated subject was thrashed out between Bangladesh and India in such a easy manner that nobody realized it. Mr. Gujarat, the foreign minister, he realized the importance of resolving the water dispute with Bangladesh. And Devagowda, the prime minister, who is actually an expert in interstate and international water dispute, you can say. He understands the concept of the basin and things. So India was able to convince itself that by parting certain quantity of water to guaranteeing quantity of water to Bangladesh, its port in Calcutta will not be affected, and there will be no sedimentation in the river in future, in Hooghly, etc. So India worked out a formula in annexure to the treaty and agreed for it. Initially, there was some protest, but even the chief minister of West Bengal, Jyoti Basu, fully agreed with the treaty. He said it doesn't affect the interest of India. And true to his belief, so far it has not affected. And the treaty is coming for a revision next year, next 2 years, in 2026. And I'm sure with more or less the same terms, it will be revised.
Sir, what are your views on the ongoing Teesta conflict between India and Bangladesh?
Well, Teesta is a more complicated one, like the disputes we have in India on Kaveri, Krishna, because we are really having a fight over the quantitative use of water. India has its Teesta Barrage project, where it irrigates about 9 lakh hectares of area. And Bangladesh became ambitious, and they too have their own planned the Teesta irrigation project, Teesta Barrage. And planned 3 crops of rice. And that was all right. But then India thought that if this is the way Bangladesh has been doing, trying to appropriate the water unilaterally, and in course of time, it can plead for protection of the existing use or prior appropriation, historical use, whatever. So India also became doubly conscious. And the Hydropower Corporation in India decided to plan a series of dams to utilize Teesta water in a non-consumptive utilization, not a consumptive, on the run of the river to produce power. So 50,000 megawatt, the plan was unveiled. As a result, the Bangladesh protested. Finally, in 2011, a draft agreement was worked out, but West Bengal opposed the draft agreement, and as a result, it couldn't be signed. And still, the dispute remains unresolved, and I don't think it can be resolved unless the government of India convinces the people of West Bengal and takes them on the board. Until then, it's difficult to resolve. Not that it cannot be resolved, but as usual, blood is thicker than water. These kind of disputes get politicized. So once the politics enters, it is not easy to resolve it unless efforts are made to convince each side. And maybe in course of time, it might happen.
So, India and Nepal also have joint projects on international rivers. Do you foresee any serious disputes between India and Nepal in the future?
Yeah, a couple of the tributaries of Ganges originate in Nepal. They originate in Tibet, then come to Nepal, then come to India. So technically, the Nepal is an upper riparian state as far as the India is concerned. But the thing is, so far, India and Nepal have worked together to jointly develop the projects and use the water. And we have got Kosi Agreement, Gandak Agreement, Sharda Agreement, Mahakali Agreement. So a couple of these agreements, joint projects have been taken. And under the joint project, the power is produced and the power is shared. So it has been a good cooperative effort so far with regard to the Nepal is concerned. And construction of certain barrages, dams also necessary in India, for India, if Nepal does, because it cuts the flood in Bihar. So from that point of also, India is keen for cooperation. So far, I feel the cooperation between India and Nepal has been working out well, despite some kind of ramblings here and there. But one dispute has been creating a lot of problem. That is a border dispute. Because the river is the border under the Sagoli Treaty of 1816, which British government had signed on behalf of India with the Nepal. In this question has arisen, where is the boundary lies, whether it's the main river or a tributary, all that. So whole thing is in a confusion. And again, a lot of politics has entered there. So at the moment, both the sides are not in a position to see the reason. But in course of time, it might get resolved. It's not such a big issue.
That would be all, sir. Thank you for this wonderful educational session. And thank you for joining us on Verdictum today.
Thank you, Ananya. I really enjoyed. It was a very comprehensive view of international waters in India. And hope the program finds its acceptance
So do I.
to the larger public. Thank you. Thank you for your good questions.
Thank you so much, sir. And to our viewers, thank you for watching Verdictum. Please don't forget to subscribe to our channel for more such informative content and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.